Welcome back. Welcome back to another Hump Day Real Estate with Kendall in the DMV. Are you a landlord or a tenant? Well, if so, this episode is for you. Did you know today, October 1st, 2025, there's a new Maryland landlord-tenant law? Tonight, we're talking about an important change, and this law is very important. If you're a renter or a landlord in Maryland, you might want to stay tuned. The new 24-hour notice requirement and the time restrictions. Starting today, Maryland landlords are now legally required to provide written notice at least 24 hours in advance before entering a rental property. Wait a minute, what? You have to provide written notice 24 hours before entering a rental property in advance. But that's not all. There are also new restrictions when they can enter. Under the new law, landlords can only enter rental units Monday through Saturday. What? Wait, you can only enter your rental property Monday through Saturday with 24-hour written notice. Wait a minute. Wow. Oh, it gets better. Between 7 a.m. and 7 p.m. It's the property you own, right? Your name, your LLC, your whatever is on it, right? This property you own. You can't enter your property without 24-hour written notice, and you can only enter after that Monday through Saturday, 7 a.m. to 7 p.m. Oh, unless it's an emergency. This is a significant change that strengthens tenant policy, privacy rights across the state. Tenants in the comment, let me know that this increase your privacy rights? Landlords, let me know in the comment how you feel about this new law. What does this mean for the tenants? What does this mean for the tenants? Previously, the rules around landlord entry varied and weren't always clearly defined. Now you have concrete protections. Your landlord just can't show up unannounced to inspect your unit or make repairs. They must give a written 24-hour notice ahead of time, and they can only come during business-friendly hours. Weekdays, Monday through Saturday, 7 a.m. to 7 p.m., unless there's an emergency. So, landlord has something to do all week, but need to schedule an inspection, won't get done. If it needs to be done during Sunday because he or she can't get off work or too busy, Sunday's not a day. So the emergency exception is very important. If there's a purse, there's the I can't talk tonight. If there's a burst pipe, fire, or other urgent situations threaten the property, your landlord can still respond immediately. But for routine matters, these new rules apply. I wonder that I wonder this is a question we can ask the folks at the state at some point. I wonder if the tenants reaching out and calling for a rodent issue or something, would that uh, go with the emergency? Because it's only it says other urgent situations threatening the property. So wonder would that fall in that place? Man, what does this mean for the landlord? What does this mean for the landlords? If you're a landlord or property manager, you need to update your procedures immediately. Anytime you need to enter a tenant's unit for inspections or repairs, you must provide written notice at least 24 hours, schedule the entry between Monday and Saturday, 7 to 7 p.m., and ensure that the entry only occurs between 7 a.m. and 7 p.m. Let's emphasize that and ensure. So you can't schedule it Monday through Saturday and somebody end up there at 6:30 or somebody end up there at 8 o'clock. It has to be between hours of 7 and 7 p.m. This the notice could be via email, text, traditional mail, but it needs to be invited in writing and documented. You also need to adjust your schedule practices. No more Sunday property tours or evening maintenance calls except in genuine emergencies. Wait a minute. Got a landlord trying to help them sell their home, the investment property. And the only day the possible buyer can come to the property, Sunday. I can't get that buyer into the property. I can't get the buyer into the property. Or if there's a turnover, tenants, we're trying to get a new applicant, and the applicant works 6 days out of the 7 days a week, and Sunday is the only day off. We can't get that applicant into the property. And per this, which is crazy, that it got something else has to come out. So you mean to tell me if the tenant agrees, we can't use the tenant to supersede what this law is? Oh man, we need some answers for that. We need some answers for that. No more Sunday property tours or evening maintenance calls except in genuine emergencies on Sunday. That's just has to be an emergency. Emergency situations like a burst pipe, fire, gas leak, other urgent threats to the property or safety. These are handled differently and allow immediate entry. Did you guys hear that though? Tenants, did you know what actually allows the landlord to have immediate entry into the home? And that's again a burst pipe, fire, gas leak, or other urgent threats to property or safety. But for routine maintenance, inspections, or showing the property, these new requirements are now mandatory and must be followed. I don't know, folks. I don't know if I want to be a landlord in Maryland anymore. What do you guys say? You already have squatters have rights, right? So you mess up and leave your door open to your house. Somebody can slide in your house, and now you have to go through craziness to get them out, right? Now you're running this business and you don't even have access into the property, and somebody, this is the property that you pay for, you pay taxes, you paying the upkeep, you're running the business, and you have no control over how to get into the property. Now I understand, because there's some folks out there, oh boy, rest in peace, Dora Kendall would go walking into her second floor unit and just started yelling the tenant's name. But she's already at the bottom of the steps. That was, that was my grandmother. Wow. She it was already at the bottom of the step. We're standing there with little kids, and she just take her keys and go in. She wouldn't be able to handle these things during these times. It would bother her like crazy because she wasn't used to not being able to use her keys to get into her property. It probably wouldn't work well. So the bigger picture, Maryland Tenant Bill of Rights. This changes the part of Maryland's Tenant Bills of Rights, which is actually the nation's first nationwide Tenant Bill of Rights. The state takes this seriously, requiring that this document be included with a residential rental lease starting back in July 2025. What particularly interesting is that Maryland has committed to updating this Bill of Rights annually. Every September the 1st, the Office of Tenant and Landlord Affairs will release an updated version reflecting changes to federal state rental laws. With those updates taking effect each October the 1st. So, folks, mark your calendars for next year because there may be an additional change coming. The recent the Renters' Right and Stabilization Act. Many of you may remember that Maryland made major changes to landlord-tenant law in October of 2024. With the Renters' Right and Stabilization Act, the law included provisions like the right of first refusal for tenants and smaller properties and expand protection during the eviction process. Today's change builds on foundation continuing Maryland's trend towards stronger tenant protections while still recognizing legitimate landlord rights to access and maintain the properties. So this is important information, folks. So uh, a seller of mine, we just went through this, and it's 2024-ish, but anything that it starts out slow because everybody don't know about it. People got the memo, but people didn't start paying attention to it. So this is very important information to your landlords out there. Tenant right of first refusal. So before we wrap up, I want to highlight another very critical right that many Maryland tenants don't know about. Now, I said to the landlords, but Maryland wrote this for the tenants. The right of first refusal. Now, you may have not heard of this, but this law has been in effect since October 2024. But like I just mentioned, it's relatively new and frequently misunderstood. And that's why I decided to talk about both of these situations tonight. Now, check this out. If you're a tenant who lives in a property with 1, 2, 3 units for at least 6 months, your landlord must give you the first opportunity to purchase the property before selling it to someone else. Let me say that again. If you live in a property with 1, 2, 3 units for at least 6 months, your landlord must give you the first opportunity to purchase that property. This is huge. This is huge for tenants who may want to become homeowners. My opinion, there's most tenants probably won't want to rent the property that they're renting, but uh, maybe they might. What I do see this as a problem, as well, have seen it as a problem so far, is when there's a landlord and tenant dispute and the landlord wants to sell, the tenant can hold this property up for this tenant right of first refusal. If they don't sign it, they don't do all the things that is requested when you have to, when the landlord has. Now, here's the crazy thing. This is some information that you guys really need. And I don't know if, and I don't remember seeing any changes through the Realtor Commission, but this tenant right of first refusal has nothing to do with realtors. So at this point, the last transaction I did, they could not blame me if I didn't know anything about XYZ, because talking to legal, that it has nothing to do. This is a the landlord tenant and Maryland. The landlord needs to get on Maryland website, or they've received some type of documentation telling them about this process, right? This is nothing. There's not a addendum that realtors have for this. No addendum. The seller actually has to upload documents that they provided to the tenant into a portal. Has nothing to do. No, agents don't have access to. Well, we can go in there because some of us are landlords as well, but that's not out. That's not the portal that you have access to if you're selling that person's property. Now here's the thing. So here's how it works. So if your landlord decides to sell or receive any offers from a third party, they must notify you in writing. Man, this gets worse, right? Here we go again. This is my property. I gotta notify a third party or second party in regards to something that I want to do with my property. I don't know about you guys. I don't know about Maryland and rental properties anymore. I don't know. They're not big on my list anymore. That notice must include information about your right to make an offer. You then have 30 days from the date of that notice to either make an offer or offer to purchase the property or decline. If you make an offer within the same or better terms than what is in the notice, your landlord must accept it. What? Yeah, well, it says or better. Or if you decline or don't respond within 30 days, the landlord can proceed with the third party. There are some exceptions. This doesn't apply if the property is being transferred without a sale. So intra-family or something like that, or through court order. But for standard sales, this right is yours, tenant. This right is yours, tenant. So what should you do? For tenants, you must familiarize yourself with the Maryland Tenants Bill of Rights. If your landlord doesn't provide it to you, ask for it. They're legally required to include it with the lease. Tenants, know your rights, including the 24-hour notice requirement, the time restrictions, and your right first refusal. If you live in a qualifying property, if your landlord enters without proper notice or outside of the allowed hours, Monday through Friday, 7 a.m. to 7 p.m., document it and consider reaching out to the Office of Tenant and Landlord Affairs. For landlords, update your procedures today Today. Train your property managers and maintenance staff about these requirements. Create a system providing and documenting written notice and adjust your scheduling to comply with the day and time restrictions. If you own properties with 1 to 3 units, make sure you understand your obligation under the right of first refusal law before listing any property sale. Now, you heard what I said. They're telling you, the landlord, the owner, this is your responsibility. This is not a realtor's responsibility. This is your responsibility. For everyone, the Office of Tenant and Landlord Affairs uh, offers training and resources to both tenants and landlords. They're there to help both sides understand their rights and responsibilities. Okay. If that's what they say, these are my closing thoughts. This change represents Maryland's ongoing commitment to balancing the rights of tenants and landlords. The 24-hour notice requirement combined with the day and time restriction provides clear boundaries and protect tenants' privacy while still allowing landlords to maintain and manage their properties effectively. That's me being a professional about that. Take off the hat real quick. I don't agree with anybody telling me how to handle my business. My business is my business. The property is deeded to me. The property, I paid the mortgage. In the state, I paid the state real estate taxes. Why can somebody come and tell me how to handle my business? I do have a problem with that, and I think many landlords and investors also will agree. That just, I don't know. Well, my goal already, to be honest with you folks, is I'm going well beyond 3 units anyway. My future investments are mostly going to be straight commercial. I don't even want to see a 1, 2, or 3 unit in my portfolio. I need big numbers anyway. We're chasing bigger dreams. So pretty soon I'll be completely done with this. And hopefully they won't come mess with me when I'm dealing with 10 units or better or something. Um, what I find particularly significant is how specific these protections are. Maryland isn't just saying give reasonable notice. They're saying exactly what that means. 24-hour written notice, Monday through Saturday, 7 a.m. to 7 p.m. That's that's it. That's that that's it. That's the end of that, right? That's so as we move forward, expect Maryland to continue refining these laws with annual updates built in the system. October 1st is becoming an important date for anyone involved in residential rental properties in the state of Maryland. That's all for tonight, folks. If you have any questions about how this affects your specific situation, consult with a qualified attorney or reach out to the Maryland Office of Tenant and Landlord Affairs. Check in the description. I left a link um, to where you go at to do the first right of refusal for the owners. And there's also a link in there for the tenant bill of rights. Hey folks, this is another Hump Day Real Estate with KENDELL in the DMV. And I hope you enjoyed this session. See you again next Wednesday. Talk to you soon.